Hi, my name is John McKinney. I'm a Deputy DA for Los Angeles County, and I want to talk to you today about a subject that is causing some confusion in Los Angeles right now, and that's the topic of cash bail. Now, we've been hearing a lot about zero cash bail or no bail policies. We've been hearing about people being released from custody who normally would have stayed in custody. And it caused some confusion amongst people about why that's happening. So let's talk about that. There are really two separate sources. One source is the emergency bail schedule issued by the Los Angeles Superior Court. And the District Attorney of Los Angeles County, George Gascon, has implemented a no bail policy of his own. Now, how are these two bail policies operating, and which one is responsible for people being arrested and released from custody? Well, it depends on the timing. Bail is set in a case at two different times. The first time is when an officer makes an arrest. When an officer makes an arrest for a substantial misdemeanor or felony, they consult the county bail schedule to determine what the bail should be. Our county superior court issued an emergency bail schedule in October of 2020. And the idea behind the emergency bail schedule was to limit the number of people who would be held in our local jails, including our county jail. The best way to think about the court's emergency bail schedule is the general rule is that bail will be set at $0 for misdemeanor and felony crimes, with certain important exceptions. Okay, so the default is zero bail with certain exceptions. And there's a list of misdemeanor exceptions and a list of felony exceptions. The misdemeanor exceptions include things like domestic violence related crimes, DUI, carrying concealed weapons, carrying firearms, misdemeanors of significance. The felony list accepts any serious or violent felony, any felony in which a dangerous or deadly weapon is used, serious sexual assault cases, sexual battery, battery with extensive injuries. There's a long list of misdemeanors and felonies that are exceptions to the rule. Now, one other important exception is an exception for repeat offenders. A repeat offender is defined as somebody who was arrested and then rearrested before the first case is resolved. So, for example, if a person commits a shoplifting is not on the list of exemptions. Let's say that person gets arrested a week later, again, for shoplifting, or really could be any crime. The emergency bail schedule says that person shouldn't be released. That's an exception to the emergency bail order. So we shouldn't be hearing about cases of people being arrested multiple times in one day or multiple times in 1 week without bail. Now, it's possible that a person can post bail, get out, and then reoffend. Post bail again, get out, and reoffend. But we shouldn't be hearing about multiple releases on zero bail if the emergency bail schedule is being utilized correctly by law enforcement. Now, I said there was a second time that bail is set in the case. Bail is set again under both normal and these emergency conditions at the time of arraignment. An arraignment is the first time a person appears before a judge. It's at that time that the prosecution will normally request bail. And the bail requested would be bail according to the bail schedule. However, we have a district attorney named George Gascon in LA County who has his own zero bail policy. And frankly, it is broader and more lenient than the emergency order. It doesn't have the same exceptions that the emergency order has. It has some exceptions, but the policy in general says that no one should be held in custody pre-trial unless they're being held on a serious or violent felony. So the presumption is that all misdemeanors, with the exception of DUIs and domestic violence, and most felonies, should be released without conditions. By and large, clearly, the DA's zero bail policy is far broader and far more lenient than the superior courts. So that's where these two different parallel no bail policies come from. One is a superior court policy instituted for emergency purposes only and with a lot of exceptions, and a DA policy that comes into play a little later in the case at the arraignment, not at arrest, but at the arraignment, that is far broader and far more generous to people getting out of custody without having to post bail. And that's where we are. So as of today, people are being released from custody on zero bail based on two different zero bail policies. And to know which one resulted in the release of a specific person, you'll have to look at the record to see at what point they were released. If they were released by a police officer after arrest, it was more likely the LA Superior Court emergency bail schedule. And if it were later at arraignment, it may be the DA's standard policy for zero bail. So I hope that helps you to understand a little bit about bail and how it works and where the zero bail policies are coming from. So thank you again. I'm John McKinney. You can follow me on Instagram at John McKinney_. You can follow me on Twitter at John McKinney_. Pretty easy to remember for both platforms. And let's keep the conversation going. If you have any comments or questions about anything I said, please send me a message and let's talk about it. Thank you.